Hi, I'm Denise and you're watching Law with Denise. So you've watched this video, right? You've watched my case summary of Hedley Byrne and Heller 1964. In that case, you will definitely know the facts of the case. You will know what was decided at trial in the Court of Appeal and in the House of Lords. But perhaps you need to find out a little bit more detail about the facts of this case, and perhaps you also need to know a little bit more about what was decided in the House of Lords and what exactly it was that the appellants and respondents were arguing in the House of Lords. If that is where you are right now, this is the video for you. In this video, we will look very closely at the facts of this case, and we will also look at what the appellants and respondents argued in the House of Lords and look at the decision reached by their lordships, and also take a look at some of the comments shared by their lordships in this case. So let's begin. Firstly, what are the facts of this case? Well, Hedley Byrne were an advertising agency. Hedley Byrne had an agreement with a company called Easy Power. Well, with Easy Power, they were going to put up ads on behalf of them, on behalf of Easy Power, and Easy Power would have to pay them back at some point because the agreement was going to be that Hedley Byrne would put up these ads, but on a credit basis. Now, Hedley Byrne were not quite comfortable with Easy Power's financial status. What I mean is that they were a little bit suspicious about how stable Easy Power were. And obviously this would affect them because they needed Easy Power to pay them back the money if they were going to put these ads up on a credit basis. So they asked their bank, National Provincial Bank Limited, to contact Heller and Partners, who were Easy Power's bank, in order to get references to determine how stable Easy Power really was financially, and then to decide whether or not they should continue with this agreement with Easy Power. Communication was made between the two banks a few times. The first communication was made via telephone, and that communication was made by National Provincial Bank Limited to Heller and Partners. According to the judgments, all these communications that were discussed in the case were agreed to be accurate. And the first one, the telephone conversation, is one in which, according to someone at Heller and Partners, someone from National Provincial Bank Limited called them and they wanted to know the following. They wanted to know, with confidence, without responsibility on our part, without responsibility on Heller and Partners' part, the respectability of Easy Power Limited and whether they would be good for a contract of between £8,000 to £9,000. The person at Heller and Partners said they gave the following reply. The company recently opened an account with us, believed to be respectably constituted and considered good for its normal business engagements. It is a subsidiary of Pina Industries Limited, which is in liquidation. But the managing director is endeavouring to buy the shares of Easy Power Limited from the liquidator. We do not believe that the company would undertake any commitments that it is unable to fulfill. After that telephone conversation, the appellants, Hedley Byrne, wanted more reassurance. So they spoke to their bank. And on the 7th of November, National Provincial Bank made contact with Heller and Partners. This time, the contact was made in writing. And this is what it said. Dear sir, we shall be obliged by your opinion in confidence as to the respectability and standing of Easy Power Limited, 27 Albemarle Street, London, W1, and by stating whether you consider them trustworthy in the way of business, to the extent of £100,000 per annum advertising contract. Yours faithfully. Then, on the 11th of November, 1958, Heller and Partners replied. And this is what they said. Confidential. For your private use and without responsibility on the part of this bank or its officials, dear sir, in reply to your inquiry letter of 7th instant, we begin to advise Easy Power Limited, respectably constituted company, considered good for its ordinary business engagements. Your figures are larger than we are accustomed to see. Yours faithfully, Purpro, Heller and Partners Limited. The National Provincial Bank shared these communications with their client, Hedley Byrne, and Hedley Byrne carried on with the arrangements previously started with Easy Power. Unfortunately, Easy Power went into liquidation And as a consequence, Hedley Byrne lost £17,000 because Easy Power was no longer in the position, or maybe never was in the position, to pay them back the £17,000 that they owed them. Hedley Byrne's response to that was to sue Heller and Partners. Hedley Byrne lost at first instance, they lost in the Court of Appeal, and they lost in the House of Lords. Let's have a look at what was argued in the House of Lords. So what did the appellants and the respondents submit to the House of Lords? Let's start with the respondents' submissions. Now, the respondent's barrister was Mr. Foster, and Mr. Foster's arguments were largely based on the precedent Candler and Crane 1951. In Candler and Crane 1951, the Court of Appeal had decided that no legal action could arise because in that case there was no contractual relationship nor fiduciary relationship established between the two parties. So Mr. Foster relied on this and argued the following. He said, firstly, there is no general duty to not make careless statements. However, he did admit that in some circumstances, a duty could arise. And when I say a duty could arise, I'm referring to the duty to not make careless statements. So Mr. Foster starts off by saying, there isn't this general duty to not make careless statements, but in exceptions, it could arise. But he said, if this duty is to arise, the duty to not make careless statements, a few things need to be demonstrated. And the first thing he pointed out that needs to be demonstrated is that there is a contractual relationship between the two parties. So a duty can arise if there's a contractual relationship between the two parties, and out of that contractual relationship, you would need to demonstrate, Mr. Foster argued, that there was a special duty held by the defendant towards the claimant to not make careless statements. Secondly, he said, if there is no contractual relationship between the two parties, it would need to be demonstrated that there was a fiduciary relationship held or established between the two parties. And out of that fiduciary relationship, it would need to be demonstrated that a special duty was held by the defendant to not make careless statements. Thirdly, he said, if there isn't a contractual relationship and there isn't a fiduciary relationship held between the two parties, it would need to be demonstrated that there is sufficient proximity between the two parties, and that with that special relationship, a special duty has arisen in which the defendant has a duty to not make careless statements towards the claimant. He did say that if one is to rely on the third category or the third limb, being that there is sufficient proximity between the two parties, damages would only flow if the losses incurred were consequential economic losses and not purely financial losses. So he's saying, if you're going to rely on the argument that sufficient proximity was established between the two parties and you want to claim damages, you would have to demonstrate that the losses suffered were consequential economic losses and not solely financial losses. So here he's saying pure economic loss claims are not permitted. Lastly, Mr. Foster said, even if their lordships could find a case which supported the idea that bankers owed third parties a duty of care, the disclaimer that Heller and Partners used meant that that duty of care would not have been established. So Mr. Foster was arguing that even if there was some piece of case law which could demonstrate that Heller and Partners actually owed a duty of care to Hedley Byrne, the fact that Heller and Partners had put forward a disclaimer when they gave these references meant that, according to Mr. Foster, Heller and Partners would not be liable anyway. Which disclaimer was Mr. Foster referring to? Remember the note sent on the 7th of November 1958. Remember that it said the following: confidential, for your private use and without responsibility on our part. That is a disclaimer that Mr. Foster was referring to. Now, what did the appellants argue in response? Now, Mr. Gardner was the appellant's legal representative, and Mr. Gardner argued the following. He said that if there is no contractual or fiduciary relationship between the two parties, liability could arise if there was sufficient proximity between the two. But he said, damages could flow even if the losses were solely economic. So here he's saying liability can arise and damages can be recovered for purely economic loss, not just consequential loss. Now, if you're not sure what I mean by consequential loss and pure economic loss, I do have a video in which I explain these two. The link to that is in the description. Now, what did the Lordships make of these submissions by the appellants and the respondents? Firstly, they decided that a duty can arise irrespective of a contractual relationship. So it doesn't matter if a contractual relationship was established between the two parties, their Lordship said, a duty can arise. Secondly, they said damages can flow for pure economic loss. So they made the decision that, one, you don't need to have been in a contractual relationship. In these types of cases, they said, what we're looking for is an establishment or development of what they termed a special relationship. And if it can be shown that a special relationship was established between the two parties, then yes, damages can flow for pure economic loss. It doesn't have to be consequential economic losses that the claimant is claiming for. Now let's have a look at how their Lordships reached these conclusions. Firstly, their Lordships confirmed that Candle and Crane was wrong. Remember, the respondents were relying heavily on Candle and Crane, but their Lordship said this decision reached by the Court of Appeal was actually wrong. It seems that in Candle and Crane, the Court of Appeal followed Lever and Gold, but in Hedley Byrne and Heller, their Lordship said they really should have followed Nocton and Ashburton, which was a House of Lords decision. And in Nocton and Ashburton, their Lordships had made it clear that an action lies from negligent misstatements if it can be shown that the defendant had a duty to be careful. So you can see that with Nocton and Ashburton, it was being made clear, or it was made clear, that we're not looking for a contract. A duty will arise if the circumstances show us that the defendant had a duty to be careful. But instead of following Nocton and Ashburton, in Candle and Crane, the Court of Appeal followed Lever and Gold. Now, the House of Lords said, if we look at Nocton and Ashburton also pointed out that Derry and Peake, one of the cases that Justice McNair relied on at first instance, and the Court of Appeal, did not actually say or suggest what they thought it said. Their Lordship said, when we look at Nocton and Ashburton, the Lords did point out that though it was previously believed that Derry and Peake said no damages could flow for misstatements that were made negligently or innocently, only fraudulently, that was not true. So when Justice McNair relied on that at first instance, and when the Court of Appeal relied on that idea that Derry and Peake said you could only recover damages for misstatements if they were made fraudulently, their Lordships in Hedley Byrne and Heller pointed out that that was not actually the case. So, one, their Lordship said Candle and Crane was wrong. Nocton and Ashburton already told us that, yes, a duty can arise for negligent misstatements if we look at the circumstances and we can see that the defendant had a duty to be careful. And they said as well, Derry and Peake did not actually say that the defendant needed to have made their statement fraudulently. So at trial and in the Court of Appeal, there shouldn't have been this reliance on Derry and Peake. And their Lordships then concluded that what we're really looking for in cases like this one, Hedley Byrne and Heller, is we're looking for the establishment of a special relationship between the two parties. We're not looking for a contract. We're not looking for some strict meaning of fiduciary relationship as it seems they were looking for in Candler and Crane. Because Lord Hudson pointed out that it seems as though one of the reasons why the Court of Appeal did not follow Nocton and Ashburton, but instead followed Lever and Gold, was because they thought they needed to identify some strict fiduciary relationship between the two parties before they could confirm that liability could arise. But in Hedley Byrne and Heller, their lordships confirmed that we're not looking for some strict fiduciary relationship. We're not looking for a contract. What we're looking for is the establishment or the development of a special relationship between the two parties. Now, in this video, we're not looking at what was meant by this special relationship. There is a separate video with that. You can follow the link in the description to find that video. What we're looking at in this video next is what was actually decided. Did Hedley Byrne succeed? Well, no, they didn't succeed. Despite all that explanation of the law, which seemed to be in favor of Hedley Byrne, the appellants, in the end, the respondents succeeded. Heller and Partners were not liable. Why? Well, their lordships pointed out that the disclaimer made on the 7th of November, that disclaimer was sufficient for them to exclude themselves from liability. Remember that disclaimer said, without responsibility. So they were giving advice, but they were giving it without responsibility. But their lordship said, in other circumstances, in other cases with similar facts, without such a disclaimer, one could be successful, because what we're looking for is whether or not the parties have established a special relationship. Now remember, if you want to understand what this special relationship was and also what the other requirements are in order to establish that a duty of care has arisen in a similar case to this one, being one in which a statement was made negligently, I do have another video on that. So follow the link in the description to find that video. Now, I hope that was useful, and until next time, take care, and remember, like, share, and subscribe. Bye-bye.